Hello everyone, I Raminder Singh, Assistant Professor of Law, City University. So today I will discuss the topic in brief about the Punjab Rent Act 1995. So I will define the information about the act in brief. So I have divided the topic in four subparts. The first part of the topic is deals with the basics in detail about objectives of the act, scope of the act and applicability of the act. And next part of the topic is deals with the duties of parties. Parties means landlord and tenant. So next topic is deals with the grounds of eviction. Grounds of evictions means on whom the basis a property can be evicted by the landlord from the tenant. So next and the last topic is jurisdiction. Jurisdiction means court, power of the courts, and mean to say to whom you will apply the petition for the eviction of the tenant. So let's start the topic one by one. So firstly, going immediately before the starting of the topic, I will inform you about that key. It is a basic important information about the act is that the act came into force in 2013. Either it is a Punjab Rent Act 1995, but it came into force with the 2013, mean to say the tenancy which has been created after the year of the 2013, that will be part of the subject matter of this particular act. Mean to say all other tenancies which has been created before 2013 is not the basically subject matter of Punjab Rent Act. So let's start the topic with the basic information about objectives of the act. Objectives of the act. So it is very much clear that it deals with the matters which are issued between the parties regarding the non-payment of rent, exactment of the parties of the tenant from the property on the basis of known users, change of users means that the property has been let out to the parties on the basis of residential purpose, but ultimately tenant has converted the purpose of the property. So there are so many issues we have already heard in the basics in the routine life about the issues between the parties among the regarding the topics of landlord and tenant. So all these are basically subject matter of this particular act. So it was the basic objectives of the act. Next is feature. Feature of the act is the basic feature is it has adopted the principle of equality. Equality means it maintain the equilibrium between the landlord and the tenant. How? Because it is not in particularly in favor of the landlord and it is not particularly in favor of the tenant itself. Because section 20 is a very important section in the act. Definitely we will discuss in the next slides. So when we will discuss the grounds of eviction, definitely it will clear the basic feature of the act. Basic feature of the act, we will define that it cannot be changed and it is basically follow the principle of equality. Okay. The next is applicability of the act. Applicability of the act means when it is be applicable, where it will be applicable. Applicability of the act. From its very title, it is clear that it is a Punjab Rent Act and it is applicable over the state of Punjab only. Mean to say, if the property is situated in the Punjab, then Punjab Rent Act will be applicable. If the property is situated and property in dispute is situated in the Haryana or Himachal Pradesh, then Punjab Rent Act will not be applicable and it will not be the subject matter of the Punjab Rent Act. So definitely the next part is of the topic is definitions. So I have shared so many few important definitions which are very relevant to understand the topic. So first definition is section 2 or urban area. Urban area is very important part of the topic. Why? Because urban area means the property which are situated in the urban area, that will be the subject matter of the particular act. Otherwise the property is not in urban area. Suppose if the property is situated in the rural area of the Punjab, then it will not be the part of the act and Rent Act will not be applicable over that property and that property will not be the subject matter and no any court will entertain the case if the property is situated in the rural area. So urban area means definition of urban area is the property which comes under the jurisdiction of Municipal Corporation of Ludhiana. Suppose if your property is situated in the Ludhiana, then Municipal Corporation of Ludhiana is the authority under whom the jurisdiction property is situated. That is a urban area property. And the property if comes under the jurisdiction of PUDA, Punjab Urban Development Authority, if the property comes under the jurisdiction of GLADA, Greater Ludhiana Development Authority, then all these properties which are situated in that particular areas will be amounted to definition of 2M. According to definition, it is a urban area. And after the property means the property which are beyond that particular area, that will be amounted to rural area, and it will not be the part of this act. So next definition is landlord. It is a very important definition. Section 2C deals with the landlord. When we will discuss the topic of the landlord, so it is a very common word, landlord, and it comes into mind, only the person who is the owner of the property is a landlord. No, the person who is the owner of the property, it could be landlord, but other than that person, the other person, the property who is not owner, who is not real owner of the property, may be landlord. How? I will take one example and it will be clear. So suppose there is a property situated in the Ludhiana urban area, and the Mr. A, who is a properly real owner of the property but residing in Canada, and Mr. B, who is the elder brother of A, residing in the same property which is situated in the Ludhiana urban area, Ludhiana city, and the Mr. B, who is the elder brother of Mr. A presently, who is residing in Canada, Mr. B let out the same property to Mr. C. So in that particular transaction, Mr. C is the tenant of Mr. B, and Mr. B having an authority to let out the property and to collect the rent on behalf of Mr. A presently, who is residing in the Canada. So in that, according to the definition of 2C, the person who has an authority to collect the rent on behalf of real owner, it will be amounted to landlord. So next important definition is section 2M. It is a tenant. Who is a tenant? Tenants, definitely who is entitled, who is liable to make the payment of the rent and other charges to the landlord is a tenant. But there are subcategories are there as well. As suppose like subtenant, mean to say there are 3 persons are there in the transactions. Mr. A, who is the owner of the property, who had let out the same property to Mr. B. Now Mr. B is a tenant of Mr. A. In that case, Mr. B has an authority by A to let out the same property to Mr. C. In that case, if the Mr. C is a subtenant for the Mr. A, and B is a tenant for Mr. A as well. As so in that subtenancy, there are 3 parties are there, and they are simultaneously on the legal obligations against each other. And next category of tenant is if the person is residing in the tenanted property immediately after the expiry of the tenancy. Mean to say when the tenancy period is over, mean to say if the tenancy period is for suppose 2 year, 3 year, and when it will be over, but the party tenant is remaining in the same possession of the property with the prior consent of the landlord, that means he will be amounted to tenant as well. So now the tenant definition is over. The next important definition is premises, because number of time I have discussed the word property. So according to section 2G, what is premises, what is property? Property, premises means any piece of building structure, mean to say any part of the structure of the building which is in form of either residential purpose or any non-residential purpose. Non-residential purpose means commercial activities, commercial transactions. Mean to say there must be a property, and property must be in proper structure of the building. Open land is not a part of the structure, and it will not be part of the subject matter of the act itself, and it will not be amounted under, comes under the definition of the premises. Mean to say there must be a proper structure of the building, either for the residential purposes, either for non-residential purposes, means any kind of the commercial activity. Mean to say there is a one warehouse which has been let out, yeah, any other kind of the factory which has been let out to the Mr. A by the Mr. X, so on. And there are some property in form of residential building, all the 2 BHK like has been let out for the residential purposes. So all these are comes under the definition of premises. Okay, now definition part is over. So next is section 4. Section 4 is a very important section because it is basically I would like to say it is a backbone of the act itself. Why? Because it deals with the valid tenancy. Mean to say tenancy must be valid. If the tenancy is valid, then the case will be sustained before the court. Otherwise, you have no any power, you have no any right to challenge the other party. So there must be a valid tenancy. How the tenancy will be valid. First of all, there are following conditions which must be fulfilled. The first condition is as the agreement, rent agreement, and rent agreement must be in written. Rent agreement must be in written and must be signed by the parties and must be attested by the witnesses. Clear? So next important point is that that particular rent agreement must be registered before the concerned registrar authority if the tenancy period is more than 1 year, like 2-year period tenancy has been created, 3-year period tenancy has been created. So in that situation, the rent agreement must be registered before the registrar authority. And the last condition is that renewal of the rent agreement. Mean to say, when the period of tenancy will be over, then both the parties are entitled, are bound by the law to renew the agreement for the next any of the time period. So it was a valid tenancy conditions. So next section is inheritability of tenancy. Inheritability of tenancy is also important point. Why? Because inheritability itself is mean to say indicate the expression of inheritance, right of inheritance. Yes, exactly. When the property is inherited by the successor after the death of the real owner, then same footing, same wording is expressed by the section 5 of the Punjab Rent Act. Mean to say, immediately after the death of the real tenant, the property will be in form of property will be in occupation, property will be occupied by the successors of the real tenant when the tenant died. It is a right of tenancy and it is a right of inheritance of tenancy. Mean to say, after the death of the tenant, the property, the right of tenancy will be devolved among the successors. Who are the successors? According to section 5, mean to say spouse. Any of the spouse is successor of the property, as a successor of the tenant who had died now. And after the death of that tenant, son or daughter is also a inheritance, and parents is also under the inheritance. They are all successors and they have a right to residing in the same property for the period of next 10 years. But the exception is that the period of 10 years is not absolute by nature. It can be challenged and the landlord can be claimed against the situation. So what is the condition on which of the basis the period of 10-year tenancy can be challenged? The condition is that if any of the spouse, if any of the successors is having any occupation or having any property in the same particular area, then in that case only the period of 10-year facility, the period of 10-year mean to say rights cannot be sustainable according to section 5. Mean to say, landlord can evict the tenant on the ground of the basis of the ground that the successors have its own occupying, having any or other property which are residential property, and they can reside at that same property if it is situated in the same particular area. Then why they are residing at that place? So that is a basically ground, and it is a challenge by the landlord against the tenant. So now section 5 is over. Next is section number 13. Section number 13 deals with the receipt for rent payment. Receipt for rent payment mean to say, obviously when the tenant is under the liability to make the payment of the rent, then there are so many modes of the payment of the rent, like online transaction, RTGS, and by way of check. So these are various modes for payment of rent and other charges which are due against the tenant for the landlord. But sometimes accordingly tenant makes a payment in form of cash. Then in that case, if the tenant makes a payment of the tenant, if the tenant makes a payment in form of cash of the rent and other charges, then immediately in that case the landlord is under a legal obligation to issue the receipt of the particular payment immediately. If the landlord fails to make the issue the receipts in form of written against the payment which has been made by the tenant, then in that case the tenant will approach to the rent authority, means rent court, to get the benefit of the making the payment. So that was also important point. So immediately just going before the next section, I will also want to deliver one important information about the payment, about the time of the payment. So it is also important because according to the act, if the time period of the making the payment of the rent or other charges is fixed between the parties according under the rent agreement, then that is okay, that period will be followed by the parties. If there is no any time period is stipulated between the parties, then according to the law, according to the act, the rent and other charges will be paid by the tenant to the landlord in the next 15 days. Next 15 days of the month, mean to say, suppose 1st of the July is a due date. If there is no any date stipulated under the agreement, then 1st to 15th of the July is the last date of the making the payment of the rent and other charges. So clearly the next section deals with the section number 14, deals with the deposit of rent by tenant. So section 13 deals with the receipt of the rent and making the payment of the rent. Now section 14 deals with the deposit of rent. So it is also important section. It is a very basic feature of the act itself. Why? Because sometimes obviously it is a duty, we are all very well that it is a duty of the tenant to make the payment, the rent and other charges to the landlord on time. But sometimes we have also seen that, and here in the news as well as other in the daily basis routine, so many issues that landlord has refused or neglect to accept the payment. In that case, the section 14 gives a power entitled the tenant to make the payment directly in the rent authority. And if the rent and other charges, tenant is able to pay, willing to make the payment and want to make the payment, but on the basis of the refusal of the landlord, on the neglection of the landlord, only in that case section 14 has been enacted in form of as a right, as a power of the tenant, and the tenant may deposit the same amount of the rent and other charges before the rent authority. So next, section number 17 deals with the duties of the landlord. Duties of the landlord, it is a very important section itself, because without the duty, act is not complete. Not only duties of the landlord, duties of the tenant is also important, and it is a next section of section number 18. So firstly, I will deal with the section number 17, duties of the landlord. The foremost duty of the landlord is that the property which would be let out by the which would be let out by the landlord to the tenant must be in tenantable condition. Tenantable condition means it must be in proper maintained structure, and the basic amenities, basic facilities must be there, like water facility, drinking water facility, electricity facilities and sewage facility. These must be there before the let out of the property. So it was a basic duty of the landlord for the tenant. Next is section 18, deals with the duties of the tenant. Duties of the tenant means tenant would have to prove a bona fide tenant forever unless he left the property. Bona fide tenant means he will not wear and tear with the property, he will not minor damage with the property, he will not demolish any part, any portion of the property, he will not any kind of the damage to the structure of the property without prior permission and without prior consent of the landlord. If he want to do, suppose if he want to whitewash the property, then firstly, but it is a basically improvement of the property itself on the basis of the tenant, but he must have to take the prior permission of the landlord. So it was the duties of the tenant. Next is section number 19. Section number 17 is for landlord, section number 18 is for tenant, but section number 19 lies obligation over both the parties simultaneously, and section number 19 deals with the cutting off or withholding essential supply or services. Mean to say, all these are essential supply services like water, like sewerage, like electricity, all these are basics, essential supplies and services. But section number 19 bound both the parties not to cut down or not to withhold the services without any just and sufficient cause. Suppose, now I will clear with by taking one example. Suppose there is one property and there are two portions of the property. So the ground floor is in usage of the landlord and first floor is in usage of the tenant. And ground floor is residing on the first floor. There is one electricity pipeline, electricity wires which are going from the portion of the landlord and going to the upper part of the portion, that means the first portion there where the tenant is residing. Mean to say there are the electricity wires which going from the portion of the landlord and entered into the portion of the tenant, and simultaneously there is a water supply which is coming from the landlord portion and enter into the landlord portions, from tenant to landlord portion. So both these two parties are enjoying the same essential supplies like electricity and water, but according to section 19 both are under bound and under legal obligation not to cut down any of the essential supply, not to withhold essential supply without just and sufficient cause. Suppose if there is any landlord want to change the structure of the property, so it is a justification. It has a justification and it is a reasonable cause. In that situation, the landlord withhold or cut down the property, essential supply for a certain period. So it is a genuine. So in that case, section 19 will not be applicable. Okay. So next is section number 20. So just immediate going before the section number 20, I would like to clear one thing in that it is a part of the basic backbone of the act itself, because it deals with the grounds of the eviction. Now from the section 20, grounds of the evictions are started. Section 20, 21, 22, 23 and 24, all these are sections deals with the grounds of the eviction. Mean to say it provides the protection from the eviction of the tenants. Protection of the tenant doesn't mean that it is properly in favor of the tenant. No. Protections means if the landlord want to evict the tenant from the property, then firstly the landlord will have to prove certain grounds, otherwise that property will not be vacated by proper court of order. So it is a protection of the tenant itself. Protection means it doesn't mean that if the tenant is residing in the property for the last 30 and 50 years, he will be the owner and he must have a right to residing the same property for the next 50 years. No. Property is always of the landlord because he is the real owner and he has a right to evict the property, but he cannot evict the tenant by his own wish freely. No. There are certain restrictions over the landlord, and if landlord want to evict the tenant from the property, firstly he will have to prove the certain grounds validly, bona fidely. So let's start the topic of the section number 20. I have wrote down the certain grounds which are very important and which are practically in usage of the courts. So it is very important, and I think it will be very clearly, I will try to clearly define all these grounds, but I will discuss only section number 20 because section 21, 22 is too much taking the time. So I will clearly in brief define the section number 20 only, but there are so many important definitions comes under the section number 20 itself, and it is all important grounds which comes under the section number 20. So I have picked the section 20 because it is a backbone of the act itself. So let's start the topic of the section number 20. First ground is non-payment of rent. Non-payment of rent means if the tenant fails to make the payment for the last 3 consecutive months, in that case, it would be the ground of non-payment of rent. But it doesn't mean that immediately if the tenant fails to make the payment for the last 3 consecutive months, landlord immediately file the case against the tenant for the eviction of property. No. Prior 2 months notice will be issued by the landlord for demand of the payment. Payment means rent and other charges. So 2 months period, grace period will be given by the landlord to the tenant for making the payment. If in these 2 months, if the tenant fails to make the payment, then immediately the landlord can file the rent petition against the tenant for eviction of the tenant from the same property. So next ground is change of usage. Change of usage means the property has been let out by the landlord to the tenant for the purpose of residential purpose. But after the period of passage of the period of 6 months, property has been converted into non-residential purpose. That means ki certain commercial activity has been started by the tenant in that premises without the permission of the landlord. So it is a valid ground for the eviction of the tenant. So next ground is known users. Known users means property which has been let out by the landlord to the tenant is still remains not occupied by the tenant, and it is a vacant for the last 6 months consecutively. So in that situation, the landlord has a right to evict the property from the tenant on the ground of known usage of the property, because it was vacant and no any family member is residing in the same property for the last 6 months. It is not coming to the usage of the tenant itself and their family members. So on the basis of such ground, the property can be evicted by the landlord. Next is unfit and unsafe. Unfit and unsafe is itself a ground for the eviction of the tenant. How it would be ground? Because the property itself is unfit and unsafe. Mean to say, so many times we have listened in the daily routine life, in the rainy seasons property are demolished itself by nature, because it was not in proper structure was not maintained by the landlord. So in that case, the property itself is not fit for human habitation and unsafe. On the ground of unfit and unsafe, the property can be evicted on the valid ground. On if it's a malafide intention of the landlord is if the malafide intention of the landlord is proved, that property is going to be evicted by the landlord without any damage of the property, there is no any expectation, there is no any anticipation of the demolition of the property in future, that means ki the landlord is malafide at here and the property cannot be evicted. So mean to say, property must be in condition of unfit, unsafe and not for human habitation. So next is repair, reconstruction or alteration. That is a ground. Mean to say, landlord want to repair the property, want to reconstruct the structure of the property, want to make any such alteration of the property. So in that it is a valid ground, because the landlord has a right. It is a property of the landlord and he has a right to alter the property, to maintain the property, to change the structure of the property. Mean to say, he want to rebuild, he want to rebuild one or more floor over the property. So in that case, he can evict the tenant from the property. So in the next point is public nuisance. Public nuisance means if the property has been if the property has been let out by the landlord to the tenant for the residential purposes, and the property comes under the area of the residential purposes, residential locality, but the tenant any other family member of the tenant continuously creating the nuisance in that property, and they are interference in the enjoyment of the rights of the neighborhood as well as, or maybe certain kinds of the immoral or illegal activities are also going on that property. So in that case, the landlord can evict the tenant from the particular property on the basis of public nuisance, on the ground of public nuisance. If all these ingredients are fulfilled and proved by the landlord, then property can be evicted, then the tenant can be evicted from the property on the ground of public nuisance. So next is right for the tenant. It is a right of re-entry. Re-entry means again to enter in the property, that is a re-entry. So in the last preceding grounds like public nuisance, repair or unfit or unsafe, these are the grounds which we have already discussed. So if the property has been vacated, if the landlord evict the tenant on the ground of these grounds like public nuisance, repair the property, construct the property, and property is not fit for the human habitation, that in all these grounds there is a one condition which will be applicable over the landlord. That is a condition is that right of re-entry. Right of re-entry means tenant has a right to re-enter in the premises. So I will take one example and to clear the point. The illustration is that suppose A, who is a landlord who let out the property to Mr. B, but now A evict the property with the proper court of order. evict the tenant from the property on the ground of unfit and unsafe, or want to alteration of the property, want to change the structure of the property. So in that case, the property if had been vacated by the order of the court, but now when the property will be restructured, when the property will be maintained, when the property will be in proper construction according to the demand of the landlord, then after the expiry of after the period of that maintenance, reconstruction, then the entry point, then the right of re-entry will come into existence. Mean to say, landlord must have to give one opportunity to the tenant to enter into the same property, and it is a condition for the landlord. And now it will be the next wish of the tenant whether he will be entered into the same property or not. It is according to the mutual understanding of the parties. So it was a right of re-entry. Next is section 20 clause Q. It is a very important section, and it is a basically most common usage ground in the court of the law. So it is a ground of personal necessity. Personal necessity is also an expression of bona fide necessity. Bona fide necessity. There are certain requirements which must be fulfilled to attract the ground of the personal necessity, and it is a burden of proof over all the landlord to prove the bona fide necessity. So first of all, bona fide means to say there is no any mala fide intention of the landlord, and necessity means necessity must be there. It is a personal necessity. So I will clear the point by one example, the topic point of personal necessity. Suppose Mr. A, who is a landlord and owner of the property situated in the Ludhiana, and it is in form of shop cum office. Now it has been let out by Mr. A to Mr. B, who is a tenant of the property, who are in using of that property in shop cum office. But with the passage of the running of the period of 5 years, Mr. C, who is the elder son of Mr. A, who is the real owner of the property and landlord, the Mr. C, who is the elder son of the Mr. A, has requirement of that particular property for their own use of the business office. Mean to say, he want to open the business office in that particular place, in that particular shop cum office which has already been let out by his father to Mr. B. Now in that case, Mr. A, who is the real owner of the property, who is a landlord in that transaction, having no any other suitable accommodation, residential accommodation or non-residential accommodation in that particular area. So all these are basic ingredients which must be fulfilled by the landlord to evict the tenant. So one by one I will discuss all these ingredients. The first is that the property is let out either for residential or non-residential purposes, and it is a now requirement of the landlord or any other family member of the landlord for the residential or non-residential purposes. And last important point ingredient is that the landlord must not have any of the accommodation, suitable accommodation, reasonable suitable accommodation in that particular area. If there is any reasonable suitable accommodation in that particular area, then that section 20 personal necessity bona fide ground will not be applicable, and the landlord cannot evict the property from the tenant on such ground. So it was section number 20. Now section number 29 clause 2 restrict the landlord. Restrict the landlord. It is a specifically section 29 clause 2 for the section number 20 for the clause Q. Mean to say, suppose I have evicted the property from the tenant on the ground of to want to start the business for my elder son. But ultimately I have vacated the tenant from the property, and court has passed the order validly by relying upon my ground, and the property has been vacated from the tenant. But ultimately after the vacation of the property, it was not into any usage by me. Mean to say, landlord has not any start business over that property and it is vacant. So that means it is a mala fide. In that case, mean to say, the landlord misguide the court process. So in that case, just section number 29 clause 2 restrict the landlord. Mean to say that landlord must have to occupy the same property which has been vacated by the court order, and it must have to be occupied within the next 2 months immediately, and it must be restart the business over that property. And the third condition is that if the property relet by the landlord to any of the tenant which has been evicted earlier, then in that case the tenant which has been evicted from the property on the basis on the ground of the basis of bona fide necessity has a right, has a remedy to challenge the landlord before the rent authority. Mean to say, the landlord has evicted the property with a mala fide intention, he evicted the tenant with a mala fidely, and he relet the same property to any other person, any other tenant on a high rate of rent. So it was the restrictions which was imposed by the section number 29 clause 2 over the landlord. So last point is deals with the rent authority. Rent authority means rent court, to whom you will approach to claim the remedy against the parties. That is a rent authority. And how will you find that who has a power to deal with the case? Mean to say, the property, if it is a property situated in that which particular area, and that particular area which comes under the jurisdiction of particular judicial member that have a jurisdiction to entertain the case. Suppose the property is situated in the civil line area of the Ludhiana city, and that there was a dispute between the parties regarding that particular property, and that property comes under the jurisdiction of any of the judicial members who have a power of rent authority. That means ki you will file the petition against any of the party before that particular judicial members who have a powers has been given of the rent authority. So these are the rent authority jurisdictions to whom you will apply to file the case to evict the tenant before the rent authority. And the powers of the rent authority, if it is a matter of concern, powers of the rent authority, it is similar to the civil court. Similar to the civil court means like to issue the summons, to call the witnesses, to produce the documents, to produce the evidence, and to conduct the trial, and then decision. And immediately after the decision of the rent authority, if you are aggrieved, if any of the party is aggrieved by an order of the rent authority, it can be challenged before the district and session judge. So clearly, so hopefully I have tried my best to give a brief information about the Rent Act. So ultimately I will define any other grounds or any other any activities or any other sections in brief in the future with a fresh topic. So thank you all. Thanks everyone. Thank you.